Law here on Kirk's Law Corner. Everybody's doing okay. Braving the heat wave. It's been a warm one. Say hello to those out there on Telegram right now. Paint Gun Spooty, Wendy, Tam, Dreaming Deer, and Ralph K. Good to see you guys. And we'll see how Rumble does tonight, because I switched it back to the dynamic stream key and all that stuff. So we'll see if it has an issue. I could have just renewed or got a new regular stream key, but a static stream key. But I'll try that next time. But for tonight, we're going to try it this way. Seems to be working over there. Thank you, Wendy. So far, so good on Rumble tonight. Yeah, Diesel D's, good to see you, brother. Ooh, boy. Yeah, that's not good on the battery for the laptop to be all swollen like that. Yeah, but it should still work plugged in. You could actually remove the battery and have it plugged in. It'll still work. Jacqueline, out on Rumble, good to see you. Hopefully it works okay tonight. Oh, let's see. All caps false prophet, good to see you. And Doug, I see you over here on YouTube. James, Abel Danger shirt. Well, actually, it says Grateful Dad. Got that from my son, essentially. Son's mother bought that for me. And link to the Telegram channel, Doug, should be in the description on the YouTube description there. Jim Valentine, Freedom Fighter, good to see you guys. Mark Bond, you made it to Rumble. We'll see how Rumble works tonight. Doug, on Telegram, you have to join the group, right? And then click on where up there in the top right hand corner where it says live. There's a little thing up there showing that I'm live, and you click on that to join the live. And then if you want to make comments through Telegram, then you have to go back to the chat there. Yep, I got you, James. No worries. And how's the audio out there? It shows pretty good over here, but I haven't made any changes, so. Okay, audio's good on Telegram. All right, are we getting? So everybody enjoy last week's Monday Night Law, going over the previous declaration for the causes and necessity of taking up arms. Before the Declaration of Independence. Many people are not aware of that. All right, Doug, you made it on there to on the Telegram. Okay, good. Quantum Kid, good to see you. And audio's good on Facebook. Thank you, Wendy. And James, thank you on YouTube. Audio's good there. Okay. So far, so good. Everywhere. Audio's good. Video's good. And Rumble seems to be working. Yay. I figured I'd make that little change tonight. Then I had a little bit of a issue with my PDF reader trying to open up a document here that I'm documents illustrating the formation of the Union of the American States. So yeah. The ultimate argument about the common law and what the common law is, right? See, the bar members have all been taught, and this is coming from Doug, but this has been argued before, and which is why I showed in Blackstone's commentaries on the laws of England, the common law originated from who? The Saxons. Oh yeah, that'd be the Christian Protestants. So to all you bar members out there, you were taught wrong. You were lied to about what the common law is. First, Blackstone elucidates that the common law is composed of maxims of law, those fundamental principles that you all talk about. That's the, as Blackstone says, to quote him, the common sense law. Common sense, as in it's common to all, right? And we're all supposed to know this, like what I cannot do in my person, I cannot do through the agency of another. Like fraud vitiates everything from its inception. Those are fundamental principles, like the plus sign, the minus sign, the multiplication sign, the division sign of mathematics. Those are the fundamental principles of mathematics that dictate the correct answer every time. Otherwise, if you do not come to the correct answer, you're not of sound mind. 2 plus 2 equals 4 because the plus sign, the fundamental principle of mathematics, dictates that that is the correct answer. So that's maxims of laws, fundamental principles that are common sense. Number 2 part is customs, which is rights as the law, which comes from the French word droit, meaning right or law. So rights and law are synonymous. So when they're out here trying to tell us, well, the law says you have to have a driver's license. Where in any Declaration of Rights does it say we have to have a driver's license? Where does it say in the Constitution where we have to have a driver's license, a license for anything? Wait a minute. That doesn't sound right. And then the ultimate part, well, a common law is stare decisis, case law. That's how it was developed in part, yes. But in our republic, right? And this is the part that they're not taught. The bar members, you're not taught. When the people came over here and were fleeing from England for religious separation, which actually started in 1215 with the Magna Carta, trying to separate from the Roman Catholic Church and Catholicism as an ideology. And let's make no mistake here. Catholicism is not Christianity. As much as many people want to say it is not. Catholicism has its own ideology. And when we're talking about religion, that's what religion is supposed to be about, is ideology, a set of ideas, a set of fundamental principles, which has a direct effect on the form of government. So, under the ideology of Catholicism, they're supposed to have rulers. That's their made-up ideology. Okay? And that's where they get the monarchy as a form of government. Rulers, kings, queens, princes, princesses. Okay? Now, when it comes to case law, it's the law of the case. And even, which I've said this before, it only applies to the parties to the case. But KrisAnne Hall says the same thing. Because we brought the common law of England with us when we came over here, starting clear back into 1606 with the establishment of Jamestown, Virginia, and the first charter of Virginia of 1606. Okay. But only those parts that were conducive to our weal are to us. Oh. No, my dog 3X ideology equals a set of ideas, not imagination. I mean, I guess it could be considered as, a figment of our imagination. But when we're talking about religion, that is a set of ideas. Now, one thing that we changed was we stripped the judicial branch. Because see, under a monarchy, it's the king, the king's bench. The king makes the law, and that's where the essentially the common law kind of comes from. But mostly bills of rights, and then into statutes. What they called statutes back then, bills of rights. Because bills of rights, to quote Alexander Hamilton in the Federalist Papers, I believe it's either 82 or 84 there, he made the argument against the Bill of Rights because bills of rights are for kings, and we don't have a king here. That's right. But American Jurisprudence, Volume 16, Constitutional Law, Section 100, says bills of rights and those merely declaratory of the common law. Where do our rights come from? Those customs. Doesn't come from case law. That's the trickery. But in our republic, we stripped the judicial branch of making law, as opposed to a monarchy. That's one little difference between our Confederate Republic versus the monarchy. That's right, Doug. Exactly. We did not delegate the power to the judicial branch to make law. No. In fact, if we read Article 6, Clause 3, It reads, the senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Nowhere does it say interpret or to make law. You are bound to support it. All public servants are citizens. They are the members of the legislative, executive, and judicial branch who are required by the people to be bound by oath or affirmation to support this. Just like table legs support the table top. The legs do not get to dictate what's on top of the table. They are bound to support it. They have no authority to alter that fundamental law. None. That's in the Law of Nations. And when they do, Law of Nations, Book 1, Chapter 3, Section 34, they have no authority to alter the fundamental law. Because it would destroy the delegations of power. How can they alter the laws of their own creation? We, the people, create it. Then the public servants can alter the laws of their own creation and expound upon their own powers? No, that's completely illogical. But Section 30 makes that a capital crime to do such a thing. We call that treason, which is a lot of what's going on right now. Now, there are many people that were involved in the Reconstruction Acts of 1871 and all that. They're not alive today. And so what we have to do is we have to take a look at the history of law, which, make no mistake, Trump most certainly knows. Right, Mark? I get it. The Police don't care about rights or the Constitution. None of them do. Again, why do these so-called judges, why do they wear black robes? If you can honestly answer that question, and you know why they wear black robes, then you know what's up. Because that is symbolism for the Roman Catholic Church. That's right. This is all Roman civil law. Uh-oh, AI has pulled your important comment, James. Well, that's crazy. Yeah, good to see you, Karen. Rumble seems to be working, and Mark and Jacqueline and All Caps False Prophet, they're all over there on Rumble tonight. But yeah, we the thing here we need to comprehend and fully understand. The corporation is done. Okay, this has been exposed, been taken down. Trump did the involuntary bankruptcy. I have submitted those documents out there. Proof that this has been done. Okay, this is a fact. The corporation is done. But that's how a monarchy works. Corporations. Oh. Corporate charters. That's right. The Virginia Company and all those other. East India Company, West India Company, the Hudson's Bay Company, all these companies, corporations. But when we say company, what's a company? A company of men is a military term. Think about that. Now, all my military veterans friends out there, you know what a company is. That's right, a company of men. That's a military thing. But that's how the monarchy works. Okay? Wow. So YouTube automatically takes comments down, huh? Weird. But yeah, that's, that's the symbolism of the black robes. Now, let's look at Bouvet's Law Dictionary, 1856. But let's look at the full title. It's a law dictionary adapted to the Constitution and laws of the United States of America and of the several states of the American Union. Union. That's a confederacy. Right? Like the preamble says. Come on. I mean, how many people fully comprehend the preamble to the Constitution here? We, the people of the United States, in order to form a more perfect union. A more perfect union. So we already had a perfect union, and a union is a league of friendship, which is a confederacy. See Law of Nations and Montesquieu and his Spirit of Laws. There are three types of republics. A democracy, an aristocracy, and a confederacy. See? See? Confederacy is not a republic. Yes, it most certainly is. And we have the right to create whatever we want to create. And that's what happened. Wow. Yeah, that's part of the reason why I really don't like YouTube too much. Too many controlling factors. Our right to freedom of speech is being curtailed by YouTube. But here it is, more perfect union. So that's a confederacy. We are a confederate republic. We're not a democracy. Most certainly not an aristocracy, so that only leaves a confederacy. Gee, what's the Articles of Confederation? The style of this confederacy shall be the United States of America. That's the confederacy. How's that? All right. Now, the other part of the title of this is with references to the civil and other systems of foreign law. Civil is a system of foreign law. Huh. Imagine that. It's telling us right here that the civil law is a system of foreign law. And this particular dictionary was entered according to the Act of Congress in the year 1839 by John Bouvet in the clerk's office of the District Court for the Eastern District of Pennsylvania. Act of Congress again in 43, in 48, in 52. To the Honorable Joseph Story, one of the judges of the Supreme Court of the United States. This work is with his permission most respectfully dedicated as a token of great regard entertained for his talents, learning, and character by the author. Ah, wow, okay. So we also have Joseph Story in his commentaries on the Constitution as a Supreme Court justice. Oh yeah, that's also a good read. But I'm going to take you down here, and we're going to look at that law, comma, civil. So we all know that the civil law is Roman civil law. Oh yeah. All right. Law, civil. Wait, what was this one? Canon law. The canon law is a body of Roman ecclesiastical law relative to such matters as that church either has or pretends to have the proper jurisdiction over. Why do we have judicial canons? Huh. The term civil law is generally applied by eminence to the civil or municipal law of the Roman Empire, without distinction as to the time when the principles of such law were established or modified. In another sense, the civil law is that collection of laws comprised in the institutes, the Code, and the Digest of the Emperor Justinian. This is the Justinian Deception, and the novel constitutions of himself and some of his successors. The institutes contain the elements of the first principles of the Roman law in 4 books. The Digest or Pandex are in 50 books and contain the opinions and writings of eminent lawyers digested in a systematical method, whose works comprise more than 2,000 volumes. The New Code, or collection of imperial constitutions. So the Code is a constitution? Aha! In 12 books, which is a substitute for the Code of Theodosius. The novels are new constitutions posterior in time to other books and amounting to supplement the Code, containing new decrees of successive emperors as new questions happened to arise. These form the body of the Roman law, or Corpus Juris Civilis, as published about the time of Justinian. Although successful in the West, these laws were not, even in the lifetime of the emperor, universally received. And after the Lombard invasion, they became so totally neglected that both the Code and Pandex were lost till the 12th century, AD, 1130 AD. When was the Magna Carta again? 1215. Wow. Wow, wait a minute. What a coincidence that the code was accidentally discovered at Amplify and the code at Ravana, when it was said the Pandex were accidentally discovered at Amplify and the code at Ravana. Now, this next part. Oh, but as if fortune would make an atonement for her former severity, they have since been the study of the wisest men and revered as law by the politest nation. You mean members of the bar? The Crown Temple Bar? So, again, let's put 2 and 2 together to make 4 here. But the shit was rediscovered in 1130. By 1215, the people had had enough and said no. Now, here's another key part. By the term civil law is also understood the particular law of each people, opposed to natural law, or the law of nations, which are common to all. So if the Roman civil law is opposed to the laws of nature and the law of nations and the common law, would that not be again? Would that not be where is it? Right here, in the Declaration of Independence. Oh, where'd it go? He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, given his assent to their acts of pretended legislation. What jurisdiction is foreign to our Constitution? What jurisdiction is unacknowledged by our laws? That's the Roman civil law, the code. Huh. But let's seal this fate, because let's look at what it says here. Judge Swift in his system of laws of Connecticut prefers the term civil law to that of municipal law. Right, because municipal law doesn't matter. It's all part of Roman law. He considers the term municipal to be too limited in its signification. He defines civil law to be a rule of human action, adopted by mankind in a state of society, or prescribed by the supreme power of the government, requiring a course of conduct not repugnant to morality or religion, productive of the greatest political happiness, and prohibiting actions contrary thereto, and which is enforced by the sanctions of pains and penalties. Uh-oh, bills of pains and penalties falls under bills of attainder. Now, wait a minute, that might sound familiar. Where have I read that before? I swear that shit was prohibited. I'm pretty sure. Article 1, Section 8, 9, and 10. Limits on legislative power and limits on the states. Section 9. No bill of attainder or ex post facto law shall be passed. Well, I'll be damned. It's right there. It's prohibited. Section 10. Pass any bill of attainder. No state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender or payment of debts, pass any bill of attainder ex post facto, or law impairing the obligation of contracts, or grant any title of nobility. It's already in the Constitution. We don't need Article the 13th. Now, wait a minute. What we've been told about bills of attainder, right? Let's see if we can find something here on this from their perspective of what they want to tell us. Where is it? What the hell is all of this? Oh. We want to go to Section 9, Clause 4. What the hell? I went directly to oh, it took me all the way to the beginning. I get it. Article 1, Section 2, Section 3, Section 4, Section 5, 7, 8. Or Section 9. There we go. Bills of attainder doctrine. Let's take a look at that. Supreme Court cases given broad and generous meaning to the constitutional protection against bills of attainder by interpreting it to ban not only legislation imposing a death sentence, as the term was used at English common law, but also legislation that impose other forms of punishment on specific persons without trial. However, the court has emphasized that legislation does not violate the Bill of Attainder Clause simply because it places legal burdens on the specific individual or group. Rather, as discussed in more detail below, Bill of Attainder must also inflict punishment. Another key feature of a Bill of Attainder is that it applies retroactively. No. The Supreme Court has held the Bill of Attainder Clause does not apply to legislation that is intended to prevent future action rather than punish past action. That's the ex post facto part, not the Bill of Attainder part. The court has also held that the prohibition on bills of attainder does not safeguard the states against allegedly punitive federal legislation. Punitive? And does not protect U.S. citizens who commit crimes abroad and face trial in other jurisdictions. Overall, the Supreme Court has suggested the court has applied the Bill of Attainder Clause to prevent legislatures from circumventing the courts by punishing people without due process of law. The Supreme Court applied the constitutional prohibition on bills of attainder in a pair of Reconstruction era cases. Oh, where's anything prior to the Reconstruction? Oh, that's not, we're not going to find any of that here. But as we can see, first of all, they're saying, oh, well, it's a felony that's death without a trial. That's what they want us to believe, that that's what a bill of attainder is. But Wait a minute. Let's go to Bouvet. This is 1856, right before the Reconstruction Acts. Come on. Good Lord, wait. Bill of Attainder. Legislation, punishment, period. An act of the legislature by which one or more persons are declared to be attainted and their property confiscated. Where does it say anything about execution without trial? The Constitution of the United States declares that no state shall pass any bill of attainder. During the Revolutionary War, bills of attainder and ex post facto acts of confiscation were passed to a wide extent. The evils resulting from them in times of more cool reflection were discovered to have far outweighed any imagined good. Joseph Story on the Constitution, section 1367, vide attainder, bills of pains and penalties. So, again, bills of pains and penalties are the same thing as bills of attainder. But let's look from history here real quick. Stop that. Let's look at the English Bill of Rights of 1689. Because this is, oh yeah, 1689. Remember, we were over here in America starting in 1606. So what was this about? By assuming and exercising the power of dispensing with suspending of laws and execution of laws without consent of Parliament. Huh. Same thing over and over again. By committing and prosecuting divers worthy prelates for humbly petitioning to be excused from concurring to the said assumed power. How many times do we have to tell them, no, this is unlawful, we don't want this crap, and we don't give our consent? By issuing and causing to be executed a commission under the Great Seal for erecting a court called the Court of Commissioners for ecclesiastical causes. How many of you states out there got your commissioners, Court of Commissioners? Yeah, Pennsylvania is one of them. How about by raising and keeping a standing army within this kingdom in time of peace without consent of Parliament and quartering soldiers contrary to law? That's them policy officers. Now, New York State Rifle Pistol Association versus Bruin case, June of 2022, Supreme Court of the United States of America. Cited this section right here about the right to keep and bear arms. By causing several good subjects being Protestants, oh, you mean the Saxons, the common law stuff, to be disarmed at the same time when Papists were both armed and employed contrary to law. In other words, no, we're going to disarm you and we're going to have armed bodies of men who are going to enforce these bills of attainder and bills of pains and penalties on you. Uh-oh. Oh, what's this? By violating the freedom of election of members to serve in Parliament. You mean election fraud in 1689? No, say it isn't so that election fraud was occurring in 1689. Ain't nothing new under the sun. Election fraud has been around as long as elections have been around. Now, here's a good one. And this should raise some eyebrows. By prosecutions in the Court of King's Bench for matters and causes cognizable only in Parliament. In other words, prosecution in the judicial branch when it's supposed to be in the legislative branch. Oh, wait a minute. And whereas of late years, partial, corrupt, and unqualified persons have been returned and served on juries and trials, and particularly divers jurors and trials for high treason, which were not freeholders. Whoops! Tampering with the jury pool. And excessive bail have been required of persons committed in criminal cases to elude the benefit of the laws made for the liberty of the subjects. And excessive fines have been imposed, and illegal and cruel punishments inflicted. Oh, wait a minute. Here's where we get into the bills of attainder. And several grants and promises made of fines and forfeitures before any conviction or judgment against the persons upon whom the same were to be levied. Oh, you were speeding. That's an infraction. No, that's a bill of pains and penalties. And the fine is because the legislature says, oh, this goes back to the general warrants and writs of assistance. Oh, wait a minute. But it's right here in 1689. That's that legislation that prescribes punishment. Well, if you do this, that's a $1,000 fine and up to a year in jail. Is that not prescribing punishment prior to? See, the jury is supposed to decide the punishment, not the judge, and not the legislature. Because every case is different. Oh boy. Greg Danuck, good to see you, brother. Recent case from Trump and the Federal Reserve. I will have to look at that, brother. That is going to probably be a very good one based on what you're saying there. A ruling that came out yesterday on the firing of Lisa Cook of the Federal Reserve. It explains the de facto banks and the fact they were de facto even before the creation of the Constitution. Trump filed this case. Wow. The Munson 58, thank you for joining us tonight. Good to see you. Tinted Bits, good to see you out here on Rumble. Late for class, cooking and listening. Well, are you cooking enough for everybody? That's going to be a feat. But yeah. Now, we've been lied to, but let's go with this thought. Let's go with just the initial thought that it's and see again, a bill of attainder must also inflict punishment. But the part I want to, the one they say is, well, it's there it is. But also legislation that imposes other forms of punishment on specific persons without trial. So let's start with that, because we'll give them that, right? We know that. And that's what we're being, all traffic tickets, all infractions, right? There are other infractions that have anything to do with traffic. Well, then, those are all bills of attainder. But wait a minute, like I said, or like I showed you. Oh, crap. Oh, no, that's in the Bouvet's, pardon me. Oh, under the Roman civil law, pardon me, I'm already over here to bills of attainder. Remember what I showed you there is that it's the Roman civil law is all enforced by bills of pains and penalties. Fines and jail time. But under the infractions, there's no jail time, so it's all just fines. Where does that money go? Where's the injured party? There isn't one. Hey, John Wick, notice that you're citing code. Code is Roman civil law. Stop citing code. 28 United States Code, 1746. Stop citing code. That's Roman civil law. Where is the Northwest Ordinance? July 13th, 1787. Section 4, there shall be appointed who shall have common law jurisdiction and reside in the district and have each therein a freehold estate of 500 acres of land while in the exercise of their offices. There shall be appointed from time to time by Congress a secretary whose commission shall continue in force. This is, okay, here it is. There shall also be appointed a court to consist of 3 judges, any two who may form a court, who shall have a common law jurisdiction. What? Not Roman civil law, the code. Common law. Article 2. Now this gets into articles, right? The inhabitants of the said territory shall always be entitled to the benefits of writ of habeas corpus and of the trial by jury. Not jury trial, but trial by jury, which starts with a grand jury of a proportionate representation of the people in the legislature. We don't have that, do we? And of judicial proceedings according to the course of the common law. According to the common law. No, statutes are not Roman civil law. Code is Roman civil law. Statutes are made by delegations of power through the Constitution in our republic. Like the power to regulate foreign and interstate commerce. The legislature is supposed to make a statute. Now I'm going to show you, which I was trying to get to that before the show, but I was having issues. with my PDF reader here. But I'm going to bring up our first legislative session. First, I'm going to bring up our Organic Act. Maybe. Where is... Okay. Where I want to... There it is. All right, so this is the Organic Act of the Territory of Idaho, 1864. We'll go down here to section 9 when it's enumerated. See, and this was created by Congress pursuant to Article 3 or Article 4, Section 3 and Section 4, the guarantee of a Republican form of government, which goes back to the Northwest Ordinance, which I have found in the legislative acts here of Idaho, that we have all of the rights and everything all the way back, and we have equal footing doctrine, the equal footing of all the original states pursuant to the Northwest Ordinance. Oh, why all the way back to the Northwest? Because that's the guarantee of Republican form of government, and that was the original first ordinance ever created to admit new states to the Union. And at that time, before the Constitution was even created, it was only the Articles of Confederation that that was the Republican form of government. Being enacted by the Senate and House of Representatives of the United States and Congress assembled, that all that part of the territory of the United States included within the following limits, to wit, beginning at, this is what? This is the metes and bounds. This was created by Congress, enacted, because that's how it's supposed to be done, to guarantee that Republican form of government. But when we go down to section 9 here, that the judicial power of said territory shall be vested in a Supreme Court, district courts, probate courts, and in justices of the peace. That's it. That's what we're supposed to have. But see, in Idaho now we have the magistrate division of the district court, then we have the district court, and then we have the appellate division of the Supreme Court, and then we have the Supreme Court. Where's the probate courts? Oh, it's all tied in. They call that civil. It's a civil case. No, we're supposed to have very specific courts for those things. And the major one that's missing is the justice of the peace courts, because those judges are supposed to be directly elected by the people themselves. And they're supposed to be in every city. The district court is the county level. And as we read through here, this can be appealed to the district court. But where is it? Where are our justice of the peace courts in the city? In every city. The Supreme Court shall consist of a Chief Justice and 2 Associate Justices, any two of whom shall constitute a quorum, and who shall hold a term at the seat of government of said territory annually. And they shall hold their office during the period of 4 years. Whoa, they're only supposed to be in there for 4 years? Until their successors shall be appointed and qualified. The said territory shall be divided into 3 judicial districts, and a district court shall be held in each of said districts by one of the justices of the Supreme Court at such times and places as may be prescribed by law. And the said judges shall, after their appointments, respectively, reside in the districts which shall be assigned them. The jurisdiction of the several courts herein provided for, both appellate and original, and that of probate courts and of justice of peace, shall be limited by law, provided the justice of the peace shall not have jurisdiction of any matter in controversy when the title or boundaries of land may be in dispute, because that is in equity, having an equitable interest in land, or where the debt or some claim shall exceed $100, an equitable interest. And the said Supreme and District Courts respectively shall possess chancery as well as common law jurisdiction. Common law. Not Roman civil law, the code. Stop citing code, folks. Now I'm going to show you what a real statute looks like. Wait, before I do that, before I show you what the real statutes look like, I'm going to show you what we're doing right now. Right? This is what they're doing right now. We can look at some of the recent ones, right? Where is it? How do I find that? Let's go back to 2025. Okay, didn't like that one. Okay. Legislature of the State of Idaho, 68th Legislature, first regular session, 2025, the House of Representatives, House Bill number 1 by Hostetler. An act. It's an act relating to income taxes, providing legislative intent, amending Chapter 30, Title 63 of the Idaho Code. Where's the statute? You're amending the Idaho Code. Why in the hell is the legislature amending the Idaho Code? Where's the statute? Huh. Imagine that. Now, let me take you over here and show you what a real statute looks like. This is the very first legislative session for the Territory of Idaho, 1864, after the Organic Act. This is the Organic Act is the law of creation, right? Okay. And then we can assemble the people. Laws of the Territory of Idaho, first session. Not bylaws, but laws. Also containing the Territorial Organic Act, Declaration of Independence, the Federal Constitution, the preemption and naturalization laws, etc., etc. Naturalization laws? Uh-oh. Look, here's the Declaration of Independence. Right in the first legislative session for the Territory of Idaho. Oh, here's the Constitution. But wait, you're going to love this. I've showed this before, but I'm going to show it again. Gonna show it again. Here in 1864, before the Reconstruction Acts, they were what? Whoops. Whoa. I went way too far. Trying to go back to that Constitution. Oh, there's the naturalization law. Man, I accidentally skipped way down. Here's the homestead law. Uh-oh, we're supposed to get like 160 acres of land. Yeah. Now, this is all put out by Congress, by the way. Not until we get to the first actual act. Oh, good Lord, did I really go down that far by accident? I was only going down a little ways. Oh, come on. And then, of course, I'll go up too far. Uh-oh. What's this? Amendments to the Constitution of the United States? Why doesn't it say of America? But what does that read? Article 1, not First Amendment. Article 2, Article 3, Article 4, Article 5, Article 6, Article 7, Article... Wait a minute. Now, Article 7, in suits act common law. Here you go. This is for you, Doug, and the bar members out there that, well, common law is stare decisis, case law, case decisions. Really? So, Article the 7th of the Bill of Rights in suits at common law is suits at case law. Make it make sense. Wrong. Not here in America. And never was even before that, because again, the common law is about our rights as the law. Otherwise, this doesn't make sense. A suit at common law, if common law is case law, then this would say suits at case law. Huh. Well, where does it say? In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Well, common law is case law, so the rules of case law. Now, again, make it make sense. Now, the common law is in fact a body of law. Period. Our rights as the law. But again, I'm really wanting to point out that in 1864 here, it is written as articles. That's because the original Bill of Rights says these are articles in addition to an amendment to the Constitution of the United States of America. These are articles in addition to. Articles. Wait a minute, that's contract law. contract law. This is a contract, which is why we require them to be bound to support this Constitution, Article 6, Clause 3. All right, now let's go back. Or wait, no. Let's go look at the very first thing that the legislature actually created. Statutes of the Territory of Idaho, Title I, an act to regulate proceedings in civil cases in the courts of justice of the Territory of Idaho. Uh-oh. Wait. This is the very first thing. This is a real statute. Being enacted by the Legislative Assembly of the Territory of Idaho as follows. Where does it say to amend the Idaho Code? Oh, wait. Now, notice that this says Civil Practice Act. Right there. Civil Practice Act. There shall be in this territory but one form of civil action for the enforcement and protection of private rights and the redress and prevention of private wrongs, which shall be the same at law and in equity. Oh, in the civil side. Uh-oh, not criminal. In such action, the party complaining shall be known as the plaintiff, and the adverse party as the defendant. Why do they call them plaintiff and respondent, not plaintiff and defendant, in accordance with this? When a question of fact, not put in issue by the pleadings, is to be tried by the jury, an order for the trial may be made, stating distinctly and plainly the question of fact to be tried, and such order shall be the only authority necessary for a trial. Every action shall be prosecuted in the name of the real party in interest, except as otherwise provided in this act. But in suits brought by the assignee of an account, unliquidated demand, or thing in action not arising out of contract, the assigner shall not be a witness on behalf of the plaintiff. Blah, 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 blah. Okay. But notice that this is the Civil Practice Act. Oh, I dropped it, damn it. Now, the second thing that they created, statute, a real statute, an act to regulate proceedings in criminal cases in the courts of justice in the Territory of Idaho. Whoa, wait a minute. A crime or public offense is an act or omission forbidden by law and to which is annexed on conviction, first, death, second, imprisonment, third, fine, fourth, removal from office, fifth, disqualification to hold or enjoy any office or honor, trust, or profit under this territory. Public offenses are divided into first felonies, second misdemeanors. Where's infractions? Huh. A felony is a public offense punishable with death or by imprisonment in the territorial prison. Every public offense is a misdemeanor. Uh-oh. You mean infractions? Don't exist here, do they? Mark, this is 1864. This is the first thing that they created. This is the first legislative session for the Territory of Idaho. Organic Act of 1864 by Congress, giving us the authority to assemble and create our statutes, the laws, right? And every single one of these is supposed to be submitted to Congress for their approbation, for their rejection or approval. And I have discovered that in here, in the legislative session laws, which I have quite a few of them, Congress said, oh, no worries, you don't have to do that. You don't have to send it over for us for approval or rejection. Section 6, every public offense must be prosecuted by indictment, except, first, when proceedings are had for the removal of a civil officer of the territory. That's because that's admiralty jurisdiction. Civil officer, elected official. Second, offenses arising in the militia when in actual service in time of war, admiralty jurisdiction. Or which this territory may keep with the consent of Congress in time of peace. Militia? Third, offenses tried in justices' courts. You mean the justice of the peace courts? Right, from the Organic Act, the justice of the peace courts, we do not have to have a grand jury indictment. Why? Because it's supposed to be anything over $20 goes over there. But that could be criminal in nature. We're supposed to make the claim for damages, and whether it's criminal or civil in nature. A criminal action shall be prosecuted in the name of the people of the United States and the Territory of Idaho as a party against the party charged with the offense. The party prosecuted in a criminal action is designated in this act as the defendant. Wow. It's actually supposed to be in our own name. But the main part there is it's all supposed to be done. You got to have a grand jury indictment. Fifth Amendment. So, what do you mean you've never seen this act before? I've showed this before. Mark? Slacking. Just kidding. Diesel D's Chancery. Chancery is actually church. The ecclesiastical stuff. Uh-oh. So that would have to do with the church stuff under Chancery. But you know, it's right here. This is a real statute. Now that I've shown you this, okay, I'm going to show you something else. Straight from the Idaho Code, right? What does this say? Let's go to Title 19, Criminal Procedure. Yeah, let's go. I want to go to Section 5 because persons lodging the complaint. When a complaint which has been subscribed to under oath by the party or parties lodging the same is laid before a magistrate alleging facts constituting the commission of a public offense triable within the county, so territorial jurisdiction, and the magistrate finds the complaint alleges a public offense under the Idaho Code or county or city ordinance, the magistrate shall order the clerk of the court to file the complaint and refer the complaint to the appropriate county or city prosecuting attorney for further action. Wait a minute. Even pursuant to the Idaho Code, it's not the prosecutor that files the complaint. It's the actual injured party or parties that files the criminal complaint. And after the magistrate finds that it violates the Idaho Code, then he sends it over to the clerk of the court to file the complaint and refer the complaint to the appropriate county or city. No, this is actually supposed to go to the sheriff with an order to assemble a grand jury for this case. Not to the prosecutor. We're the prosecutor. But look at what they're citing. Criminal Practice Act of 1864, Section 102, page 226. But let's go look at Section 102 and see what it reads. Are they lying to us? Yes, absolutely. Because we'll go down to Section 102 in the Criminal Practice Act of 1864, which we're looking at right now. Whoops, I went past it. Nope, right here. Section 102. When a complaint is laid before a magistrate, the commissioner of a public offense triable within the county, he must examine on oath the complainant or prosecutor and any witnesses he may produce and take their depositions in writing and cause them to be subscribed by the parties making them. Now, don't get confused with what it's saying the prosecutor here. Because we'll find out when you can exclude people from this initial examination, that the defendant can exclude everyone except the complainant and his assistants of counsel, the attorney general, the prosecutor. Wait. How is that? There's all these different people that are supposed to be in the courtroom, and again, we all have the right to prosecute our own claims. Now, why is that not there? And notice the page misconception, page 248. Well, they're saying here is 226. Wrong. This is the first legislative session. Exactly, 1864. And just so we're clear on this, I have actually verified this down at our Idaho Law Library, which they actually have all of the legislative session law books. I have quite a few of them, but they don't start until like early 1907, 1909, and then I have a lot of them from the 80s, and 90s. Thank you, Rob Logue, for that. We got those for $1 a piece. Somebody was just getting rid of them, thinking that they were just supposed to be, staging props at motels or whatever. So, as we can see here, we're the ones that are supposed to lay the complaint, not the prosecutor. Now, here's where we look at this history, right? What does it go into? RS, that's revised statute. Statutes cannot be revised, they can only be amended. Then we got revised code and codified law. Then we got codified statutes. I mean, how many times are you going to change the verbiage here when what you're actually doing is it's all fucking code? Revised code, codified law, codified statutes. It's all trickery. Idaho Code Annotated, ICA. No. And now, I'm going to expose when this actually happened. When the Code of Procedure Act, wait, I already showed you the Civil Practice Act and the Criminal Practice Act. Was it the 8th or was it the 11th? Now, see here, still being published. This is the 8th legislative session for the Territory of Idaho. Okay? What do we got here some morning? Yeah, I don't care. Notice they're still showing them as articles. This isn't the right one. This is not the right. It's the 11th. The 11th legislative session, 1881, in Idaho, before we had the Constitution. How many blank pages we got here? Now, see, now they're calling it general laws of the Territory of Idaho, including the Code of Civil Procedure, passed at the 11th session of the Territorial Legislature, 13th day of December 1880, and adjourned on the 10th day of February 1881. Are you ready? Code of Civil Procedure, an act to establish a Code of Civil Procedure for Idaho Territory. We already have the Civil Practice Act. What do we need this for? Wait a minute. When we read this, what does it say? Section 3. The rule of the common law that statutes and derogation thereof are to be strictly construed has no application to this code. The code establishes the law of this territory, respecting the subjects to which it relates, and its provisions and all proceedings under it are to be liberally construed with the view to effect its objects and promote justice. The provisions of this code, so far as they are substantially the same as existing statutes, must be construed as continuations thereof and not as new enactments. Code. Here it is. The code. Here's the proof that they altered the fundamental law from common law to Roman civil law. I have told you this before many, many times. I have showed this before, and I'm showing it again. It's right here. Here is the proof. That's because Roman civil law is opposed to the common law. Blackstone in his commentaries on the Blackstone's commentaries on the laws of England also says that the Roman civil law is opposed to the common law. So here's the proof. And this is what I challenged in my current case. I have done a constitutional challenge to this act, that they have altered the fundamental law from common law to Roman civil law, the code. I want this declared unlawful and unconstitutional, because now you're subjecting us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, and given his assent, the governor is given his assent to their pretended acts of legislation to amend the Idaho Code. No, get rid of this Roman civil law, the code. Yeah, 1881, Mark. This is 1881, before we had our Constitution, right after the Reconstruction Acts. So this is where they turned us back into a corporation and back under the monarchy and under Roman civil law, which is why the judges all wear black robes. Do we get it yet? Do we get it yet? Seriously. Plain and simple. Can we put the two and two together here? Being subjected to a jurisdiction that is foreign to our Constitution, unacknowledged by our law. The common law doesn't acknowledge my State Organic Act, the Northwest Ordinance, the Bill of Rights does not acknowledge this body of law. Code. It's all Roman civil law. Do we see the big picture here? The bigger problem? You know, this is Idaho, they'll say Idaho statutes, but then this is all code. Roman civil law, the code. Right? Yep, you bet, Mark. 1864 with the Organic Act. First legislative session with the Civil Practice Act and then the Criminal Practice Act, which they say that they're citing this from, but they have no authority to alter that. Period. So basically, remember, fraud vitiates everything from its inception, like Chris and I used to talk about, where the wheels fell off the wagon. That's the first instance of fraud. So, where's the first instance of fraud here? In 1881. So everything from 1881 on is void for any effect for fraud. Because we go back to where the wheels fell off the wagon with the Code of Civil Procedure Act. That wagon is still sitting there, stuck in the sand, stuck in the dirt, stuck in the mud, whatever, where the wheels fell off. And it wasn't usurped in 1889, it was usurped in 1881. So now you know. Here's the proof. I mean, I don't know what more proof you all need to see that this is all Roman civil law. I mean, what are we looking at here? U.S. Code. Uniform Commercial Code. Code. Roman civil law. U.S. Code. Roman civil law. Code of Federal Regulations. Roman civil law. Well, Mark, question is, can it be a state after 1881, or is this word salad? It's word salad. And remember, the state is actually the people. Oh, they don't want us to know that. Law of nations. What is the state? It's a state of being of the people, and the people have all political power. The people are the sovereign. So them trying to label us as sovereign citizens when they are the citizens, the public servants, the city servants or civil servants, the people are the sovereign, the servants are not. We're not, no, we're not the, we're not citizens. We're the people, the inhabitants. Oh, what was I? I was going to go to something there. Oh, well. Forgot where I was going to go with that. Oh, Ninth Amendment. Article the 9th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Well, all political power is retained by the people. All of it. Every last bit of it. All of it. That means we are the sovereign people. It's the people. And they want to keep calling us the citizens when we're not. Choice of words, choice of jurisdiction. But what does disparage mean? Uh-oh. Let's go to etymology, right? Degrade socially. Oh, you're one of them sovereign citizens. That's a disparaging statement, label. They're trying to degrade us from the sovereign to being subject to their authority. For marrying below rank or without proper ceremony from Anglo-French and Old French, blah, 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 blah. Reduce in rank, degrade, devalue, depreciate. Originally, to marry unequally, marry to one of inferior condition or rank, and thus, by extension, to bring on oneself or one's family the disgrace or dishonor involved in this. Also from late 14th century, as injure or dishonor by a comparison. You're one of them sovereign citizen constitutionalists. That's disparaging. They're trying to deny our rights being sovereign. Especially by treating as equal or inferior to what is of less dignity, importance, or value. Sense of belittle, undervalue, criticize, or censure unjustly is by 1530s. I wonder how much more. No, where is it? Disparagement, a match into one of inferior rank or condition. Yeah, we're supposed to be maybe this will make a little more sense here. First of all, preamble for Idaho. We, the people of the state of Idaho, grateful to Almighty God for our freedom. Wait a minute. We're grateful to Almighty God for our freedom? To secure its blessings and promote our common welfare to establish this Constitution. Declaration of Rights. Whoa. That was some weird stuff over here. Inalienable rights of man. Unalienable. Of man. All men are by nature free and equal. Free. What does it mean to be free? Hey, Mark, you're citing Roman civil law. I know it's good. I know it's good, Mark. But you're still citing Roman civil law, the code. Revised Code of Washington, RCW. No, we're not kings, we're masters. Karen, people equals sovereign. Okay, kings? No, master. The one in charge. But what does it mean to be free? Free from governmental interference. As opposed to slaves. And equal. Go, what? Disparage. Unequal. Right? To degrade socially. To make us unequal. Words have meanings. So, by nature, oh, you mean like the laws of nature? Right, right. So, something like this in our Idaho Code. Title 9, Evidence. Judicial knowledge. Facts judicially noticed. Facts. Okay? We're talking about facts that can be judicially noticed. One is the true signification of all English words and phrases. The true signification of all English words and phrases, and of legal expressions. How about the laws of nature? Oh, we can do judicial notice on the laws of nature, but notice what their history is saying. What's the CCP of 1881, Section 896? Is that not the Code of Civil Procedure Act? It most certainly is. So in part, it's a trickery. Basically, you don't have these rights under Roman civil law unless you put them on notice claiming those rights. So that's in part of the trickery, right? Because the laws of nature is coeval across the whole world. Blackstone's Commentaries on the Laws of England. And any man-made law that comes in conflict with the laws of nature is void for any effect. So they're preying on our ignorance. They're preying on our ignorance of our rights, the law. But it's right there, the laws of nature, judicial notice. What is that? All men are by nature free and equal and have certain unalienable rights, even though they write it inalienable here, among which are enjoined, this is among, that's not all of them, enjoying and defending with arms life and liberty, acquiring, possessing, and protecting property, pursuing happiness, and what? You mean we secure our own safety? Right, Mark? Like a king, just don't touch me there, as Chris used to say. Man, I miss that, man. Fix it fast. Quit citing Roman civil law, the code. That's a foreign jurisdiction. No, fix it fast, you missed it. Code is Roman civil law. I just showed you. You're going to have to go back and rewatch. I showed the proof. Code is Roman civil law. It is a foreign jurisdiction. It is foreign to our Constitution. It is foreign to the laws of nature, the laws of nations, and the common law. That's our law. So, here we go, folks. What are we going to do? We have these rights. And these rights cannot be taken away from us. Because these rights come from nature. So like I said, who's with me? Because if you're not with me, you're against me. And I'm for America, American values, principles, morals, from the Christian ideology, the Ten Commandments. So, I disagree, Mark. We only have shit made up for law these days. No, the common law is still there. That's our law. Our law. We dictate that the common law is the law. We dictate that the laws of nature is the law. We dictate that the law of nations, or the principles of the laws of nature as applied to the conduct of nations, is the law, not the Roman civil law, the code. It is up to us to do something about it. Again, Trump, at his inauguration speech, clear back in January of 2017, he flat out told us that this was not a transfer of power from one administration to another. Right? This was a transfer of power from Washington, D.C. back to you, the people. All political power is inherent in the people, not American state nationals, not citizens, right? All political power is inherent in the people. Government is instituted for their equal protection and benefit, and they have the right to alter, reform, or abolish the same whenever they may deem it necessary. So, when are we, the people, going to come together and claim and exercise our rights, our powers? When? When's that going to happen? To quote Carl Miller, hey, somebody ought to do something about that. We'll be a somebody. Right? Well, Mark, we're being freed. We have the military been deployed to the states. But the main thing, you know, it's this right here, folks. Right of assembly. The people shall have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives. That means we're the sovereign. We're the ones with the power to tell them what to do, and to petition the legislature for the redress of grievances. So the first part is the right to assemble peacefully. That's the grand jury. That's called a presentment, a grand jury presentment. When we sit around and we consult for our common good, and then we instruct our representatives, that's a presentment or a petition. Okay? It's right here in writing. I just showed it to you on the screen. What are we waiting for? I have never said that we're supposed to sit around and wait. Trust the plan. So many people brainwashed and indoctrinated can't even get the truth right about what Trump said and what we're supposed to be doing. We have a despotic government right now, folks. And it's up to the people. And I know this is difficult because We've all been lied to. We've all been dumbed down. Even the judges, even the attorney members of the bar, they've all been brainwashed and indoctrinated. They've been taught wrong. And that is what actually where God came in and softened my heart, because before that, I was pretty angry about all of this. Now it's like, oh, okay, wait a minute. We're supposed to have compassion for our fellow man, right? And, okay, what would Jesus do? He didn't come here to save the good guys, right? He came here to save the sinners. Uh-oh. But that doesn't mean that we're supposed to tolerate the tyranny, the oppression. We do have the right, from the laws of nature, to defend ourselves. The right to shun what may be harmful from the laws of nature. We have the right of self-defense, which is exactly where the Supreme Court went in the New York State Rifle Pistol Association versus Bruin case in June of 2022, citing Blackstone's commentaries on the laws of England, that our right to keep and bear arms comes from the laws of nature, naturally, fundamentally, and principally. Imagine that. So, here we are. Sitting around twiddling our thumbs, doing nothing about it. We got to have the knowledge to gain the power. Then we have to learn how to wield that power. And then we can go into battle. So the first thing is to assemble the people, to consult for our common good, and figure out how to take this power back, how to exercise this power, how to wield the double-edged sword. Right? Because our tongues are sharper than a double-edged sword. So when we have this knowledge of the law, and we know what our rights are, and what powers we have, we can speak the law. I know what my rights are. Good, tell me about them. Speak it. Well, so you don't actually know what your rights are. If you can't speak it, you don't know it. You might know where to go find them and read about it, but you don't actually know them. If you cannot speak this off of the top of your head, you do not know what your rights are. You do not know what you're talking about. So for those that are joining a little late, like making the comment, all state codes were written by the U.S. Congress, Texas Government Code Chapter 311. No, it's all Roman civil law. The code is all Roman civil law. It wasn't written by U.S. Congress. It was written by your state legislatures. Now, to know the difference is to say no to the difference. And what I'm referring to, the difference between the common law and Roman civil law. To know, K-N-O-W, the difference between Roman civil law and the code, and common law, is to say no, N-O, to that difference. Okay? But we have to gain this knowledge, and I've just given it to you on a silver platter. You all should know this by now. You should be able to remember that code is Roman civil law, and that we are supposed to have common law as our law. Plain and simple. Commit that to memory. Learn that. remember this video. Save it. Share it. Like, follow, and share. And by all means, please help support. Donation links are down in the description there. Buy me a coffee there at buymeacoffee.com, or you can subscribe through Patreon. You're welcome, Jeanette Stewart, out there on YouTube. All right. All right, everybody. I think that was a pretty good one for tonight. Hopefully some people learned some very much needed knowledge tonight. I really, really hope this code crap that you now know that is Roman civil law and that it is a foreign jurisdiction. Okay? That is, if you take away anything from tonight, please, please take that particular part. Code is Roman civil law, and it is a foreign jurisdiction. Yes, Doug, actually, I just saw that, actually. So, thank you, Doug. Thank you for all the other subscribers out there on Patreon. We'll see you on Wednesday night for Patreon Wednesday Night Workshop. Those of you who are looking for one-on-one time with me, help with the case or what have you, that's tier 4. Okay? So, much love, everybody. God bless. Have a wonderful night. Be safe out there. And start talking to your friends and your neighbors. I mean, we have social media. Why can't we just use that already? And then meet in person. Leave your phones in the car. Meet privately. Okay? And consult for your common good. What are we going to do? Come back here and learn some more. And if you want more in-depth stuff, get into the Wednesday Night Workshop, okay? God bless. Much love. Have a wonderful night. Good night, everybody.